Well, good morning, everyone, and good afternoon for any of you that are dialing in from Eastern Canada. It's my pleasure. My name is Paul Conway. I'm the Executive Director with the ADR Institute of Alberta. It's my pleasure to welcome you today to the joint ADRIA and FOAJ, that's the Foundation of Administrative Justice. We feature these luncheons on regular monthly basis, and we look forward to doing that in the months ahead, so please keep watching for details. For those of you that are online that have military service or are first responders, it's certainly my pleasure or my opportunity to thank you for your service to your country and to Canadian citizens. We've got Naval Captain Bruce King with us today. It's November, it's Remembrance Week, day, month, and it seemed to be an appropriate choice of topics. The law of war is, of course, a branch of dispute resolution that stretches our imagination and our resolve to see international conflicts resolved in a appropriate fashion, and that war crimes do not persist in the world. So I'm going to take a few seconds to introduce the two host organizations. I'll start with ADRIA. So the ADR Institute of Alberta is the professional association for mediators and arbitrators in this province. It's part of a network of affiliates across the country under ADR Canada. We certainly invite you to visit our website at adralberta.com and take a look at the programs and the information that's there. We have online and in-person training opportunities for those of you that are interested in learning more about dispute resolution at any level, because it's a great asset in your lives. We also have an online directory of ADR professionals in Alberta that you might want to check out. So I invite you again to visit the website, and on that note, I will introduce Karen Popov. She's one of the co-executive directors at the Foundation of Administrative Justice. Karen?
Thank you, Paul, and welcome, everyone. I am one of the executive directors at the Foundation of Administrative Justice. We are a training organization that is dedicated to education and training for the administrative justice community. Our courses help build confidence and success in individuals and organizations, as well as saving time and money in making and writing decisions. The Foundation offers a certificate program for decision makers, advocates, administrators, and investigators. Some of our courses are interpreting legislation, decision making, decision writing, investigations, plain language, and cultural competencies. Our 2021 calendar should be coming out in the next few weeks, so please look for that. Livestream has created many opportunities for the Foundation to do our work in a different way. One of those opportunities is that today, one of our CTAJ graduates from Nairobi, Kenya, is joining us on the Lunch and Learn. Welcome, Amy. Thank you for joining us. The Foundation also has a bursary program where we give out 2 bursaries of $1,500. The deadline is December 1st. I encourage you to send in your applications by then. To get more information, visit our website under About Us to get the application. Thank you and enjoy the webinar. Back to you, Paul.
Thanks, Karen. And as Karen mentioned, we have attendees from across the country today and as far away as Kenya. So welcome to everybody and thank you for joining us. I've got a few admin announcements before we introduce Bruce. I would invite you to use primarily the chat feature if you wish to ask questions, and I will moderate the presentation both during but certainly after Bruce has finished his presentation. You can use the Q&A function as well, but we tend to monitor the chat a little bit more closely. This presentation will be recorded and posted, and the PowerPoint slides that Bruce is using will be shared with those that are attending today. So, you can take notes by all means, but we will share as much as possible and post the recording. Our December event has not been finalized yet, but please watch on the website and your emails for details. We look forward to hosting you then as well. Let me move forward to recognizing that today we are meeting on a virtual platform, but as individuals, we participate on lands previously occupied by our Indigenous peoples. We are encouraged to remember their heritage and history, as well as the important contributions of many races and cultures in our shared history of settlement and immigration in Canada. Let us begin by acknowledging that for thousands of years, the Indigenous peoples have walked these territories, weaving their identity and spirituality intimately with the land. We acknowledge with respect that we live, work, and play on lands that were often delineated by treaty or otherwise occupied by settlers. Keep us mindful of the many covenants and treaties that we have made, and often broken, with our Indigenous peoples. Knowing that they have suffered, may we find new ways to live with respect on this land, moving into reconciliation as we journey forward together. Thank you. It's now my pleasure to introduce Captain Navy Bruce King. Now, for those of you that are not familiar with military rank, naval captains and colonels are one rank below general officers and flag officers. And actually, Bruce progressed through most of his officer corps ranks as an Army officer. We sometimes tease the Navy that, you know, it's the only branch where the captains, the colonels want to be called captains and the captains want to be called naval lieutenants. But Naval Captain Bruce King has certainly served with distinction. He is a native of Edmonton, Alberta. His bio, of course, is online. I invite you to read it in more detail. He graduated from the University of Alberta and practices here in Alberta, of course. In 1999, he joined the CF as a reservist. He's deployed at least 4 times to Kananaskis, the Vancouver Olympics. He served there, Afghanistan as well. In 2017, he was promoted to his current rank of naval captain, and he is appointed the Deputy Judge Advocate General for the Reserves. Since 2012, he's also been a sessional instructor at the Faculty of Law at the University of Alberta, where he teaches military law. He's eminently qualified to speak on today's subject. In 2014, he joined Veterans Affairs, where he works currently, but he still serves as a reservist. It's my pleasure, Bruce. I want to thank you for your service to Canada, and we look forward to your presentation.
All right, I'll start sharing my screen. Hopefully you can see my PowerPoint presentation. There we go. Just give me a moment to fuss with my technical difficulty. All right. Well, welcome everybody. I'm happy to have an opportunity to speak to you about international law, and in particular, the role of the military in international law. I'll be focusing on kind of the intersection of how the military and how in international law, there are alternative dispute resolution mechanisms that are employed. And as I go through this, you'll start to recognize that the toolbox used on the international stage looks an awful lot like the toolbox we use for local disputes as well. Many of the tools that are available in international law and used in diplomacy try to achieve the same results that we often see locally. I did want to indicate that the views that I'm presenting today are my own. Don't necessarily reflect the views of the Canadian Forces or Veterans Affairs, so you should take it as my comments and not anyone else's. So I just want to start off by saying that you know, Canada and other nations have interests, just like individuals, and in the pursuit of those interests, we attempt to influence other countries to adopt a certain kind of behavior or to adopt a certain stance which is favorable to Canada. And so we have an entire department of in the Canadian government, now called Global Affairs Canada, which is focused on diplomacy and really trying to use some level of influence over other countries, either to maintain a status quo of some particular feature of interest to Canada, or to change the status quo to something more favorable. And I've put on the PowerPoint slide a few examples of things that there are literally dozens and dozens of interests that countries have that are pursued. But these are some of the ones that that sometimes are in the news around Canada. You know, we pursue an energy policy. We're trying to encourage the export of energy, for example. At the same time, we're trying to have a climate change policy. And in the pursuit of that, we are attempting to influence other nations to our point of view. Similarly with Arctic sovereignty and other kinds of, many countries have different kinds of border disputes. They try to influence international law, how it looks at the way that borders are drawn around countries. And to the extent that works for Canada, you know, we support that as well. And so the key is that nations pursue interests in everything that they do. And what's different, though, about nations from individuals is that nations endure, like corporations, for a very long time. And people tend to, whole peoples tend to associate their sort of identity with the nation that they're in. And so individuals will take great pride in events like the American Revolution, you know, events literally that happened, you know, 250 years ago, they take great pride in. And because of those long memories that nations have, it influences somewhat the way that we conduct our affairs. And I'll talk more about that in a couple of minutes. For the most part, a country like Canada, which is a middle power, we're not a strong military power like some of the superpowers, we tend to use something called soft power. So we use institutions like the United Nations, the WTO, the World Health Organization. Canada participates in those organizations. And through persuasion, logic, you know, friendly talk, serving on committees, we attempt to influence those committees and those institutions to take positions favorable to Canada. And other countries obviously are also pursuing those agendas, and frequently, because we share values with many democratic countries, we often come to the same conclusions, and there's often a meeting of minds. And as a group, we often try to persuade others. So the G7 tries to persuade as a group other countries, or NATO as a group tries to persuade other countries. And this kind of persuasion is soft power. One thing available, though, to nations, not available really in any other form, is hard power. And hard power is the use of the military. Sometimes the only kind of influence, particularly other dictators will respond to, is really the threat of overthrow of their government or the use of the military against them. So a country like North Korea, if there wasn't a strong military presence by the South Koreans and the Americans, they may have certainly expanded into South Korea and tried to hold that territory. And so it is unfortunate, but there are times when we have to exercise hard power. And from time to time, Canada participates in the exercise of hard power, World War I, World War II being kind of notable examples. When persuasion is successful, it often results in agreements or treaties that are signed by the countries that are interested. And the expectation is that these treaties are a win-win, that they advance the interests of all those who sign on. So it may be that we sign a free trade agreement with Europe, and we're trying to open up sort of doors so that we can market Canadian products like poultry and meat and Canadian wine. And they're opening up, you know, doors to Canada because they want to sell products like wool or other kinds of products like that they grow, and we're trying to create that mutually beneficial arrangement. And for the most part, Canada's been relatively successful in exercising its soft power and being persuasive. But there are times when situations become intolerable, where the status quo is not capable of being changed, and the only recourse that's left is the use of force. And so Canada has always tried to invest in institutions, participate in institutions, to avoid reaching that point of an intolerable situation where the only resort left is to actually use military force. So sometimes I think the Canadian government sees it as a failure if we end up in a situation where we have to use force. That means that we weren't successful in our persuasion efforts in the various institutions we participate in. I have there a couple of situations where really the status quo became intolerable for people. you know, in the American Revolutionary War, the colonists in North America had some demands of the British government, their government, that just simply weren't met. And the British government took some steps and did some things which just aggravated the situation. And the situation simply could not be tolerated any longer. If the British had been more accommodating of the Americans, we might be British North America rather than Canada and the United States. Things may have been different if they had reached an agreement and there had been some kind of accommodation. But because of that inflexibility, what was left was war. And I'll talk more about the Treaty of Versailles later on as well, but the Treaty of Versailles is the peace treaty at the end of World War I. And you can imagine at the end of a war, one army is surrendering and you have other powers that are victorious. The surrendering power really has virtually no cards to play in a negotiation about what the peace is going to look like. And in some ways, the Allies in World War I extracted an unfavorable treaty from the Germans. They limited the size of the German army. They required the payment of reparations that because of the oppressive nature of it. And so the lesson there that has been learned by nations when they're negotiating peace is that even though you might be victorious, you got to be fair-minded and try to help the nation you just defeated get off the floor and sort of rebuild. And the contrast is with what happened after the end of World War II. At the end of World War II, there was also peace agreements with Germany and Japan. But rather than keeping our sort of boot on their throats and requiring reparations and that sort of thing, we did the reverse. We created the Marshall Plan. The Americans, pumped billions of dollars into Europe and Japan to allow them to quickly rebuild. And that's proven to be very successful. Japan and Germany became almost immediate allies and partners with sort of the rest of the democratic world. And it showed that our approach to how we settled those two disputes really made a difference to the next 20 years. We didn't settle World War II in a way that led to World War III. It was settled in a way that allowed those nations to prosper. So the takeaway is foreign affairs, when we can't conduct it in the way we want to, you sometimes end up in a situation where it becomes intolerable. And we go to war. But one thing is clear, all wars will eventually end. And so when military planners and foreign affairs officials and diplomats are looking at the conduct of armed conflict, they're always thinking about what does the end state look like? What does the end of the war look like? How do we reach a successful resolution of this with the least amount of carnage? And we recognize that for the nations that we're fighting, we can't just, we can't be like the Romans in Carthage where we, enslave everyone, kill everyone, and then destroy the city and salt the earth. There has to be a favorable ending. And what that means is we have to conduct our military affairs in a way that encourage the settlement of the dispute that led to war. If you conduct your military operations in a way that results in high civilian casualties or the destruction of cultural property that's treasured by that society, it becomes a barrier to ending the conflict. So you can imagine if Canada went to war with Egypt and we destroyed the pyramids as part of that conflict. It'd be very difficult to have any kind of meaningful negotiation with the Egyptians. And honestly, we would be looking at centuries of Egyptians resenting and hating Canadians for that. And so thinking about how the war will end, thinking about the kind of agreement, because all wars do end in agreement, what that's going to look like, is part of the military planning and what that will look like. There was a Prussian military thinker, Karl von Clausewitz, a long time ago, who just kind of made the observation that nations are attempting to achieve certain goals, and when persuasion doesn't work, they have a policy goal they want to achieve, and if they can't achieve it through persuasive and friendly means, war is what you're left with. And you have to always remember that when we're going to war, we're trying to achieve an end result, and we're trying to end that conflict as quickly as we can to create a new status quo that's favorable to us and the kind of policy that we want to have. But one thing that's pretty clear about why governments want to avoid wars is that they have uncertain outcomes, for sure. Diplomacy, settlement, using other kinds of dispute resolution are much more favorable than actually going to war. And the costs of armed conflict are enormous. At the start of World War I think countries took it pretty casually. I think the Germans thought that they would march, they would avenge the death of Archduke Ferdinand, and it would be over in a few weeks. And all of a sudden it became this intractable dispute involving tens of millions and millions of deaths. You just don't know where it's going to go. And in the kind of environment we are now with weapons of mass destruction and cyber warfare, the costs, you don't know what the costs are going to be going into an armed conflict. You don't necessarily always know the capabilities of your enemy, and they can surprise you, and the kinds of damage they can do to you could be irreparable. And then obviously we're losing our young people in the armed conflict. And so for the most part, if you're going to war, the end of the wars, people are relieved that they're over, but they often don't feel like they were winning. In World War I, there's the famous battle that happens at Vimy Ridge. What you're seeing on the screen now is a Canadian burial party from soldiers that were involved in Vimy Ridge. Vimy Ridge is seen as kind of a great event in Canadian history. It's when the 4 Canadian divisions fought together for the first time. And some historians like to say that that's kind of when Canada found its nationhood. And so when you go to the memorial at Vimy Ridge, there's a beautiful memorial there, which you'd kind of think, because of the way historians talk about it being a glorious moment for Canada, it's when we came together, it's when we became a nation. You think that you would see, Greek gods and goddesses holding laurel wreaths in the sky and that sort of thing. But in fact, Vimy Ridge Memorial was built in the 1930s. So it was built by people with fresh memories of World War I. And what you see when you go to Vimy Ridge is actually not great statues to triumph and victory and, we kicked ass and that sort of thing. What you get is sorrow. You get the cost of having to go to war, and the cost of failure of not being able to negotiate. And that's what Vimy Memorial really sort of encaptures. Is not the victory or the win, but it remembers the loss and the cost. So it's important that that war be seen as a last resort, and there is a road to war that's kind of identified in international law. That international law is found in international treaties, conventions, customary international law. Customary international law is it's an unwritten law. It's very similar to a kind of common law. It's unwritten norms that nations feel bound to follow, or rights that they feel bound to offer to others or that they have for themselves. And so there's a sort of a written body of law in treaties, and then there's this unwritten body of law in these norms and customary international law, which kind of shape the road to war. And the road to war exists because nations have tried to contain sort of the carnage and damage that occurs when countries are aggressive and attempting to grab territory and that sort of thing. And so in international law, we see armed conflicts which meet these conditions, these 5 conditions, as being legitimate if these conditions are met. So it's known by a Latin phrase, jus ad bellum, but it's really sort of the right to war, or the right to have a conflict. And first of all, it's recognized that The proper authority means that it's a nation. Because international law is made by nations, essentially the only proper authority to declare a war is a nation governed by a sovereign of some kind, whether it's a president, a prime minister, or whatever their title is. And that it be publicly known that they're at war with another country so that other countries understand that conflict is going on and what is happening. There's a sense that there has to be a just cause, that there has to be a right intention. It can't just be narrow national interests where you want to grab oil fields like Saddam Hussein did in Kuwait, where he's just simply marched in several divisions into Kuwait and basically grabbed their land and their wealth. He did not. His march to war was seen as illegitimate, which is one of the reasons why the international community came against him and coalesced against him to overthrow him. So there's this sense that there has to be a just cause. There has to be a probability of success. There's a lot of suffering involved and destruction involved in armed conflict. And so there's this sense that it's futile to cause destruction when you don't have that possibility of success. And so international law sort of requires that there be this kind of probability of success. There's also a sense of proportionality that the violence that you return is proportional to the violence that you've suffered. So if you have a country attack and seize a port, for example, that you will use enough force to repel them from that port. That doesn't give you license to go and take over that other country. That you'll just do enough to return to the status quo that existed before the use of force. And then finally, because of the terrible consequences of war, international law expects that it will be a last resort and that other nonviolent options be declared and used first. So at the end of World War II, the international community came together and said, in the last 25 years, we've had two terrible conflicts that have resulted in millions of deaths, and we can't have this go on any longer. And so they created an institution that's very imperfect and not great. But if we didn't have a UN today, we would try to still invent the UN. The UN has some aspirational goals, which try to promote peaceful means of settlement of disputes and to remove the threat of war. And so right up front in the United Nations Charter in Article 1, there's an indication that all of the countries that have signed the UN Charter are invested and prepared to support international peace and security and to take collective action when necessary to remove any threats to the peace. So there's this recognition that right off, an aspirational recognition right off that we want to avoid war and use other means. Also in the UN Charter, all of the members, which are virtually every nation on earth, agree to refrain from the use of force against other countries when they can. So there's, again, an aspirational view to not using force. When there are concerns about a country's behavior, and this goes on to this day, countries like Iran or Iraq in the past, some African countries, there is a mechanism to be engaged. If countries are concerned, they go to the United Nations Security Council. The Security Council has permanent members and elected members. The 5 permanent members are the 5 nuclear powers at the time that the United Nations was created. The Security Council can then issue findings. They can essentially issue directions to other countries about how they will resolve disputes that are starting to boil over. And probably the most significant tool that the UN uses is when there is a dispute that comes along, typically what will happen is the Security Council will appoint a special representative of the Secretary General. So this is essentially somebody who's a senior diplomat who acts, they're called a special representative, but they essentially are a mediator And they will conduct diplomacy, shuttling back and forth between capitals, trying to understand the dispute, diffuse the dispute, all the things we see in just, a basic landlord and tenant dispute, just done on a grander scale with more in the balance. The United Nations can also direct and try to encourage the use of other kinds of tools. So you see there, seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, resort to regional agencies or arrangements or other peaceful means. And this is really the first stop. This on the road to war, this is where the UN tries to go first, is to bring the disputing partners together. And when they can, they do try to offer solutions as well. So it's common when there's this friction and you see military buildup by two countries, you may see peacekeepers that will be appointed by other countries that come along and participate. One of the reasons why Canada is seen as a strong peacekeeper, and not just because we have a sort of a reasonable military, but we don't have a colonial past and we don't have a history of grabbing territory or trying to be a hegemon or a superpower. And so Canada is often seen as kind of a fair broker in some of these disputes and a desirable partner to have in the United Nations in peacekeeping, which is why Canada is typically asked to do that. It's very difficult for European countries, particularly to go to places like Africa and do peacekeeping without, and this is what I mean about long memories about how nations have behaved and how people remember. It's very difficult for European countries to go into Africa and negotiate or mediate disputes because of their colonial history and some of the atrocities that were committed there. So countries like Canada are very helpful in that regard, and that's why we see Canadian troops sometimes deployed on peacekeeping missions. So we see special envoys and special representatives being deployed all of the time, and you'll see from this that an envoy's been appointed in the Libya dispute, and then it says, it's a new envoy after months of deadlock. It also shows that international affairs is messy. Countries are pursuing their interests vigorously, and as a result of that, you sometimes get a certain deadlock from the UN Security Council because of that. And so this dispute resolution is not clean at all. It's messy because of the diplomacy involved and the competing interests of different countries. And where this process starts to fail and you have aggression by a country, then what you're left with is Chapter 7 of the UN Charter. So Chapter 7, this is where the Security Council can authorize more stringent measures in terms of blockades, it's basically stopping economic relations of some kind. And we see that now where there's sanctions on countries like Iran, where they can't trade in certain goods, they can't buy or sell certain goods internationally. And so you see those things. And that's where the UNs don't stop. And I see, just having a quick look at the comments, we don't have a colonial past. We do within Canada, but not outside of, not in Africa, for example, in the same way. So the Security Council can authorize blockades, sanctions, very coercive means to try to change the behavior and alter the status quo of the particular country that's involved. And if that fails, then the UN Charter ultimately authorizes this, and this has been authorized from time to time, particularly when Saddam went into Kuwait, that the Security Council will authorize an armed force to use such measures as it seems as are necessary in order to resume sort of normal relations. And so there can be the use of military force as necessary. And so this is seen as kind of the last resort. This is the suggestion that there's been a failure by all of the negotiation means, and this is what you're left with. But anybody facing a Chapter 6 sort of order where the UN Security Council is encouraging you to settle, they will, the country that's sort of the object of that will be thinking to itself, look, if I can't settle this dispute, then the only thing that's left is they're going to come in with hard power and with military power. And that's what I'm left with. And so when the UN starts to make these orders to encourage settlement, it is, with a view that if they can't make that work, then the last resort will be employed. So at international law, we have this jus ad bellum. So we have this road to war, and we have tools in the toolbox to try to diffuse disputes of different kinds. But where that fails, and you go to an armed conflict, there are again a set of laws that arise about the conduct of how militaries are to behave during the course of an armed conflict. And all of those laws have some very basic objects and goals to them. So it's recognized that in an armed conflict there is terrible suffering, and as part of that, the laws of armed conflict attempt to reduce that suffering. They do it by limiting armed conflict to the militaries that are involved. The militaries can only attack each other. They're to leave the civilian populations alone. They're not to cause environmental harm or harm to crops and that sort of thing that might be necessary for the sustainment of those civilians. And ultimately, the goal is to conduct your operations in a way that get to that restoration of peace. Every armed conflict ends in an agreement, all of them. And so you want to make sure that the way that the conflict is conducted sort of supports that. So these are the concepts. So we have those broad objectives, and these are the concepts that really shape how the law of armed conflict work. That the military, when it's using force, that it's being controlled, that there's not an unlimited ability to just cause violence in a city or something like that, that it has to be, there's an expectation that it has to be controlled, and that the use of any force is directed at the other military and only the other military in order to get that military to a point of submission. Because when that military reaches the point of submission, that's when the stage has been set for an agreement and a peace to happen. When one military or the other can't sort of push the other to that point of submission, you can't get to that point of agreement. So military commanders are very focused on sort of degrading the other military in order to reach that kind of end state. So there's this concept of military necessity. And the military necessity sort of acknowledges that there will be violence because of the way that militaries clash, but that it'll be controlled. It's expected that when militaries are fighting, that they will differentiate between military objects, civilians, and civilian objects. So in international law, we divide the battle space up into combatants and non-combatants. So combatants are people in uniform that belong to a country. They carry their arms openly, so everybody knows who the combatants are. And then you have civilians, and the obligation of civilians is not to carry arms, to not participate in the fighting. And by not participating in the fighting, they are then privileged by not being attacked. And so commanders make these distinctions. Same with military objects and civilian objects. So these are buildings and vehicles, that sort of thing. That military objects are things like you'd expect. It's tanks, it's military bases, it's military airports, things like that. And civilian objects are cultural things like churches, the pyramids, the Louvre, things like that. These are objects that should not and cannot be made the object of attack. And military commanders are very alive to this. They recognize that there's no advantage to inflicting unnecessary harm. That inflicting unnecessary harm prevents the ultimate goal of trying to get to that peace agreement. The same with the way that we use our weapons. the design of weapons. We cannot, it's illegal under international law to design weapons in a way which increase suffering. And the weapons can only be used for legitimate military purposes. And so some weapons, like chemical weapons and things like that are clearly illegal now for use in armed conflict. And then finally, it's recognized that there's this concept of collateral damage, that sometimes there are civilians that may be in a bad place that is a military object. So to just use a simple example, many countries will have some kind of Ministry of Defense building. And at night, there may be military members in there, but there may also be a half a dozen janitors doing some work as well. And so there's this concept of proportionality that, unfortunately, for those janitors, even though they're civilians, their loss is seen as sort of permissible because of the overall advantage to destroying an important building like that. So we have this concept of combatants, and there are some privileges that go with being a combatant. So combatants are always affiliated with a nation. They wear the uniform. They agree to apply the laws of armed conflict. They carry their arms openly, and they are responsible to a chain of command. Where those conditions are met, then those individuals will be considered as being authorized by international law to participate in armed conflict. But because they are openly carrying their arms and in uniforms, they also may be attacked by the other military, and civilians cannot. So there's that distinction. In order to reduce the suffering of combatants, if combatants are wounded to the point where they can't defend themselves, or if they're taken or if they're captured, they're entitled to a prisoner of war status. So that means that they are to be treated humanely. If they need medical care, that their dignity, as their religious dignity, their personal dignity, will be respected, and that they'll be treated in a way that's humane. So that means no torture, and it also means that prisoners of war are not they're not criminals. They're not put into prisons with populations. I'll show you some pictures in a moment of prisoner of war camps that were in Alberta in World War II. We don't mix prisoners of war with criminals, because prisoners of war are not criminals. They're entitled to what they call combatant immunity, meaning that for any killing that they've done of enemy soldiers while in uniform, they're not charged as murderers. They're not dealt with as criminals in that way. Because it's recognized that the militaries, when they're clashing, are, causing significant damage and harm. And so the upshot of that is that when the armed conflict is over, prisoners of war are entitled to be released and to go home, which is very different than what happened with war criminals. So war criminals are people who actually break international law, where they've actually executed prisoners. That's probably the most common example, or where they've wantonly killed civilians. Those people are war criminals, and they will be dealt with as criminals, and they will receive a sentence for their crimes if they're convicted, and they serve their sentence. So the conflict may be over, and they may be sitting in jail for another 20 years after that. But for normal prisoners of war, for the rank and file soldiers, they're entitled to go home. And that's part of this restoration of and facilitation of peace. Is as soon as there's a peace struck, we want to sort of normalize. We want the soldiers to go home, go back to their previous jobs and that sort of thing. So there's a question: what is the penalty if prisoners are not treated fairly? Well, in the Nuremberg trials, some of the people were executed. So the penalty can be anywhere from imprisonment up to execution. That's what's been done historically. And during war, what would be considered murder? So a military member killing another military member in uniform, they're combatants. That's legitimate killing. That's not seen as a crime. Where combatants kill civilians unjustifiably in some way, or combatants kill prisoners of war, or kill combatants who no longer can fight because they're hors de combat, which means that they're injured to the point that they can't defend themselves anymore. Those are crimes. Yes, so one of the questions is Canadian soldiers are put on trial and at least one jailed after Somalia. So in Somalia, what happened in Somalia was the airborne was deployed there, and there were Somalian teenagers, so not combatants, Somalian teenagers were breaking into the camp and kind of stealing stuff. And one of the officers said, well, the next time we catch a guy, let's rough him up a bit and teach him a lesson. That's a crime. And then, of course, everybody knows the history. The Canadian soldiers got carried away. They tortured him. And those are clearly criminal acts. Those were not justified at all. And they would have been criminal acts if they had been combatants, which they weren't. But even if they had been combatants, once they're held in custody, they're to be treated humanely. And so one of the reasons why we have a military justice system, the Canadian military has its own military justice system. It's to punish Canadian soldiers for breaches of orders like this. This was obviously not well received by the military and was severely punished. So the way that we conduct operations matters. These are Iraqi soldiers in Gulf War I that are surrendering. And it's recognized in international law that when you hold up the white flag like that you're surrendering. And international law requires that if somebody wants to surrender like this, that they are allowed to surrender. You can disarm them, and then you can take them, you can detain them, and they have to be treated humanely. The reason why I'm showing this is that you have to ask yourself, why did these guys give themselves up? And then ask yourself, if when Canadians were fighting in Afghanistan, why would a Canadian never give themselves up to an Al-Qaeda member? And why would Canadians fight to the death? And that's because the Allied powers that were involved in Gulf War had a reputation for respecting international law. And it was known that if you gave yourself up to an Allied soldier, that you would not be harmed and you would be treated humanely and you'd be taken into safe circumstances and the war would be over for you. This is a good thing. Sometimes you hear really harsh comments on social media and other places where people say we should kill them all. But the fact is that we want the enemy to feel that they can give up, that it's safe for them to give up. We don't want to fight an enemy that says, my God, I'm going to get beheaded. I'm going to fight to the last man. We don't want to be in that place. So these soldiers, the conditions for success in the Iraq War were set in World War II and other places where the Allies treated where prisoners were treated humanely. They had some confidence that if they gave themselves up, they wouldn't just be executed. And so the reputation really matters. People say to us today, why would we treat ISIS or Al-Qaeda humanely? Because they certainly don't do that for us. And that's because this is not our last armed conflict. We will have Canada will be in another armed conflict 5 or 10 years from now. Don't know where, don't know when, but history is we probably will be. And we want the enemy to know that we respect the laws of armed conflict. And if they want to give themselves up, we will happily take them as prisoners and keep them safe and treat them humanely. There's an operational effectiveness to it. It's not just the law. It's actually a very useful thing. So there's a question, why doesn't the UN get involved when countries decide to use their military against their own people? That's a good question. So the UN doesn't have its own military. The UN has to ask member countries to provide troops. And starting in the Kosovo conflict, there was this concept of responsibility to protect that started to emerge, where in Yugoslavia, the Serbian government was ethnically cleansing and committing genocide against an ethnic minority in its country. And it hasn't sort of crystallized to international law yet, but it's recognized that when a nation oppresses its own minorities where there's ethnic cleansing, genocide going on, that the international community, through this concept of responsibility to protect, there may be a legal basis to authorize another country to go in and protect that minority. The thing is, though, there are oppressed minorities in the world, and the cost of trying to protect those minorities may be too high or too intolerable. There are some allegations about the Chinese oppressing a minority within its borders, but practically, because of the size of China and the Chinese military, it's extremely difficult to put together a peacekeeping force of any sort of that would be effective, and the cost just becomes too high to anyone. And as a result, nothing gets done because of the enormous cost it would take to do something about it. So there are practical realities and limitations to what nations are able to do or what they can do. I'm sorry, I'm just see a bunch of questions just all popped up.
As you can see, Bruce, there's a lively conversation going on in the Q&A, and I applaud you for
I'll try to speak to some of
it. You're doing fine for time.
Okay.
And that's great. And I will try to cover any missed questions when we get to the end. So
yeah,
at your discretion, I think it's great that you're following.
Yeah, okay, no, that's great. So there's a question about what if it is not murder of a civilian, but rather the raping of the women? What is the protection in place? So there's a number of protections. Certainly if a Canadian military commander learned that there had been criminal acts committed by a Canadian soldier, they have a command responsibility to take steps. And we have a military justice system that authorizes them to do that. So we can enforce Canadian law against Canadian soldiers anywhere on earth. And for commanders that, if they don't take that responsibility seriously, they themselves can be charged with failing to respect their command responsibility. So they have their own responsibility and liability for that. And so the expectation is that under our military justice system, we would pursue that. Any comment on the blooding initiation by Australia military recently revealed where prisoners were shot? Yeah, so I served with the Canadian Special Forces in Afghanistan, and I actually had an opportunity to see how different special forces operate in the world. What the Australians did are crimes, and the Australians also have a military justice system. And I'm sure that this will, if it has not started already, will trigger a criminal investigation. And if those, if the criminal investigation warrants laying of charges and a trial, then that will occur, and those soldiers can be will be dealt with that way. Our criminal justice system, and theirs as well, have more severe penalties for soldiers than for regular civilians for many kinds of crimes. So because they're in a position of trust is too strong a word, but they're in a privileged position, and there are obligations that they have to protect prisoners and not do what happened there. So this is seen as a great shame by Australia and an embarrassment for them when other militaries look at them, in the same way that Somalia was a shame and an embarrassment for Canada. So I think we'll be hearing a lot more about this blooding initiation and what's going to happen there. So I'll just come back to this photograph. So we have Iraqis who are prepared to give up because of the reputation of the Allies of treating prisoners humanely, which is why we, in our armed conflicts now, treat people humanely. There's a couple of photographs here which are kind of interesting. The top left photograph is in Wainwright, Alberta, that POW camp eventually became CFB Wainwright. And there's German POWs that are exercising there. And the German POWs there, they played sports. They had an opportunity to play board games. There were even some of the prisoners of war were entitled to leave the camp. Some worked on farms, and some were doing correspondence courses with the University of Alberta. And you got to ask yourself, why would we do that? And I think military professionals looking at this maturely recognize that these are really, they're young farm boys from Germany, in Austria, places like that. Some of them are conscripts. And if we want them to sort of be peaceful while they're prisoners of war, so we have to give them activities to occupy their time. You can't just put them in a bare room and have them do nothing and stare at walls. But we also, I think, saw an operational opportunity that treating them humanely like this and letting them, in some cases, some of these prisoners were writing letters home, believe it or not. And they were talking about how good the conditions were in the prisoner of war camp. That was thought to be helpful at the end of World War II. At the end of World War II, as the Germans were collapsing and the Russians were taking no prisoners. And so the Germans were fighting really to the last man because of that. And on the Western Front, the Germans were prepared to give themselves up to the Allies because they knew that they'd be treated humanely. And that facilitated the end of that conflict. And the sort of hate between Russians and Germans ran deep because of the atrocities they committed to each other's soldiers. And it's made sort of the restoration of normal relations between Russia and Germany difficult. And for us, I mean, we were at war with Germany until 1945, and then literally within a few years later, we're enacting the Marshall Plan, and then they became a key ally in NATO. And that's possible because of the way that we treated prisoners, because of the way that we conducted our operations. Similarly, you can see a hockey team there in 1946. It's partly recreational activities help them not be idle and fight with each other and that sort of thing. But this was seen as humane, and this was seen as something that would facilitate settlement and peace down the road. Again, remember, none of these POWs are criminals. They're farm boys who've been conscripted or looking for adventure, got into the war, and we detain them so they don't fight against us, but we don't treat them as criminals. And so we have that sort of history of humanity in the way that we treat them. One of the things that happens, and politicians fall into this trap unhelpfully for us sometimes, is they really vilify the enemy. They vilify the enemy to a point where it becomes really difficult to reach a settlement with that enemy. And so there was a member of parliament named Jack Layton back in 2006, 2007, who suggested that it might be a time to negotiate with the Taliban. And of course, that led to other parties and other members of parliament saying, "Oh, you're naive, you're stupid. We don't negotiate with terrorists. We're tough. We don't negotiate with terrorists." So, but the next time you hear a politician say, "We don't negotiate with the enemy or terrorists," ask them, "Well, how does it end?" Because if you're not going to negotiate, that means you have to track down and kill everyone. That's not going to happen, because the way when you start that much carnage and killing, you just create more recruits for them. And so Jack Layton gets ridiculed in 2006 and 2007 for that. And then we flash forward, to the present, and we're back to an agreement. And so you got to ask yourself, well, why didn't the Americans do this 12 years earlier? They would have saved a lot of suffering, a lot of dead Canadians, a lot of dead Afghans. And it's because the politicians were kind of put themselves in a box to make it impossible. So in the future, I'm hoping that politicians will speak more reservedly and keep open the door to an agreement, because that's how these conflicts end. They have to end it with some kind of agreement. So, every war ends. And we hope that at the end of it, we can achieve something favorable, because again, Canada is pursuing some interest. We're hoping that at the end will look something favorable for Canada, that restoration of peace involves the troops going home on both sides, on all sides, and that trade relations, cultural relations can be normalized. So in order to achieve those agreements, we have to kind of limit the violence that we do to respect international law and norms, so that we set the stage for getting to that agreement that always comes at the end. And we conduct our operations this way, even where the other side doesn't necessarily respect the laws of armed conflict, because we're setting our reputation to make it possible for the members of that next military to want to give themselves up. So I just want to finish on one sort of, it's kind of a comical sort of end to an armed conflict. So what you see on the screen here is the man with his hands in his pocket is General MacArthur. And this is the Japanese signing the document of surrender on the USS Missouri at the end of World War II. And, big moments in history. You can see all the troops there. The signing is happening. Now, the thing that's kind of humorous is the instrument of surrender is on the left, and this is the signature page on the right. And when you look at the signature page, you can see that MacArthur signed at the top, and then Admiral Nimitz signed, and then you get down to the Canadian one, Dominion of Canada representative, and it's blank. And you look below that and you realize the Canadian signed in the wrong spot. And because he signed in the wrong spot, every other representative beneath him had to sign in the wrong spot. So I think we've all seen with clients, they sign in funny places sometimes. And even in moments of great gravity, human nature can't help itself, and you see these you see the signature in the wrong place. And I've seen lots of agreements where that happens, where they're signing where the notary or the commissioner for hose is supposed to sign, that sort of thing. Anyway, it's something you see in real life, and it happens on the big stage too. Okay, so I'm going to turn to some of the questions. So Jim McCartney had a question. How, if at all, does Guantanamo fit into this framework? Really good question. So international law is designed for combatants and non-combatants. So combatants are state actors that subscribe to the laws of armed conflict and have a chain of command. And Al-Qaeda didn't fit into that. Al-Qaeda were civilians participating in hostilities. And for the moment that civilians are participating in hostilities, international law allows for them to be attacked. But if you can capture those individuals, they're to be treated as criminals. Civilians that participate in war are criminals. And so what the Americans did is they were capturing people at Guantanamo Bay, or capturing people in Afghanistan, and they ought to have been treated as criminals. And but the US, I don't think, trusted its legal system. To put them through the legal system would have meant bringing them to New York or somewhere like that and putting them on trial. And I don't think they trusted their courts. And so they created this zone where they detained them. They were not prisoners of war because they weren't combatants. But at the same time, they weren't offering them criminal trials, which is the flip side. They're either prisoners of war and combatants, or they're criminals. And that's the sort of legal process that you have. By putting them in Guantanamo Bay, I think it was thought that it would put them beyond the reach of habeas corpus. That if they got lawyers and went to court, the government would be able to hold them. So the government wanted to hold them so they wouldn't fight, and they wanted to get intelligence from them, but they didn't want to treat them as prisoners of war or criminals. And so they didn't fit into any legal framework, and it's highly problematic what happened in Guantanamo Bay. It just doesn't fit into a legal framework. The Soviet Union kept German soldiers as forced labor for many years, as forced labor and a form of reparations. How was this permitted in light of the right to repatriation of the conflict? Yeah, international law does not have clean mechanisms for enforcement or for remedies. Only recently have we created an international criminal court through the Rome Statute, but back then there was no real way to deal with that. The only real option for the Allied powers to enforce that would be to make demands on Russia, which I think they did, and then would be to use force in order to have them released. And there just wasn't an appetite to do that. Russia, by that time, their military was enormous, and they were formidable at the end of World War II. and they, a few years later, were a nuclear power. And so there just was no effective remedy to compel the Soviet Union. Now, the rest of us, have memories about how the Soviet Union dealt with prisoners of war. It's going to cause problems for the Russians in the future if they end up in an armed conflict, because they've now created a reputation and people remember how they've treated prisoners and what happens to them. And instead of it being helpful, it may not be helpful. Does the law of war apply to international water? If not, what governs what happens in international waters? So yes, the laws of war apply in international waters. Armed conflicts, naval conflicts obviously are carried out all the time in international waters. So the laws of armed conflict or laws of war do apply there, even though that no country is claiming sovereignty over those areas. So I just see one more question. In terms of use ad bellum, you mentioned earlier the notion of cyber attacks and the difficulty in determining the damage. How would a government adapt and apply the proportionality section of the justice of the war approach? Yeah, so that's a very good question. You would have to see what harm is suffered in the attack in order to decide what the proportionate response would be. And when you unleash a cyber attack, it may have unintended consequences. And somebody points out it always comes down to your best alternative to a negotiated agreement. Absolutely. Absolutely. And many international institutions have developed to try to avoid armed conflict. We've had armed conflicts, but the institutions we have are imperfect, but they help. If it wasn't for the UN, you might still see North and South Korea at war, or one of those countries may have disappeared. So I think that's all the questions.
Bruce, you're doing a great job with the Q&A, and there's a couple that I'll throw out there in a second. But
sure.
And we have lots of time for Q&A. So I invite those that are attending. We still have over 75 people online to type in your questions. Send them to all attendees so that Bruce doesn't have to repeat the questions, or that I don't have to necessarily. But it's been a great presentation, Bruce, and I know I had the privilege of taking 2 weeks of military law or law of war when I was attending staff college in Toronto. And of course, it's all very aspirational, and it conflicts with reality. And war is messy. There's no doubt about it. There's a sense that there's less civility, than some of the civility that we saw perhaps during World War II. Some cultural icons that were bypassed, like Rotenburg, and even the Vimy Ridge Memorial apparently was bypassed for destruction. Although Hitler also raised Warsaw, in response to the uprising there. There's a sense that it's hard to play by the rules when there are so many that are not playing by the rules. People wearing burqas or non-traditional combatants. We've talked a little bit about Guantanamo Bay. But I'm wondering if I can get you to comment on two things. The law of armed conflict and international law in this area is very much evolving. It's evolved during the world wars. It's evolved since. We have international courts, which I don't think you've had a chance really to comment on yet. I was just wondering if you could give us your impressions of, as it continues to evolve, what is the hope for the future? What is the hope for the international courts? The US are not subscribers to that, for example. Do you see hope on the horizon? And as messy as it is, and as many folks that don't play by the rules, is there hope for the future?
Yeah, so there's a few things. As technology has improved, the weapon systems have improved, and the ability to bring violence has become more surgical. So, I think we've all seen photographs of Dresden and places like that in Germany, where whole cities were carpet bombed in order to hit an industrial area. Now the weapons are so precise, you can pick a window to shoot the missile through, and it's relatively accurate. So technology is making the strikes more surgical, but technology is also making the reach deeper as well. You don't have to leave Iran in order to attack the United States. and they don't have a capability to take troops from Iran to the United States to launch an attack. But technology through the internet and cyber attacks is opening up a whole new realm for them. And small countries can actually be quite competitive in the cyber realm. So, so technology is really, really transforming that. You mentioned the International Criminal Court. The International Criminal Court is the first time a permanent court has been created to deal with essentially war crimes. But what's happened is they really only deal with the big fish. They try to capture a leader. It's very difficult to collect evidence in a war zone and to make a case. And so, and the criminal court has limited resources and has to sort of pick its battles with the kinds of groups it takes on. So there is some sort of hopes for the International Criminal Court, but it's very limited in its reach.
Yes, and Canada certainly has played a role in that with some of the justices that have been appointed there, but it is, as you've suggested, it is limited. There is a question, you've touched on Guantanamo, and that of course brings us to perhaps a controversial topic in Canada, that is Omar Khadr. And there's a question posted on the chat right now about child soldiers. General Dallaire, of course, is very involved in the child soldier issues. Some folks online might have taken part in a recent presentation from General Dallaire, actually. Can you comment a little bit on that aspect, and without wading too deep into anything that's going to get you into trouble, the Omar Khadr situation?
Well, Omar Khadr brings, people have strong views on both sides of that. And that's because it brings into conflict a number of values that we have. Omar Khadr was a child. So what do we do with child soldiers? Because that's a reality. He seemed to have had a strong-willed father. And so, what level of sort of punishment or forgiveness should be accorded, because he was only, I think, 15 years old at the time. At the same time, he has agreed to a statement of facts and recanted on a statement of facts, but in it he admitted to killing a medic and killing medical personnel who are claiming protected status is a war crime. So he's involved in the hostilities as well. So it brings in a number of conflicting values. And people feel strongly on all sides of it. It's not the last time we'll have a difficult sort of conflict of values, but it's a tough case because of that.
For sure, thanks. I appreciate that, Bruce. Some of the other questions that are popping up is just the current status of the Geneva Conventions, and I think that is part and parcel of the evolving law of armed conflict, but you can comment on it. There were also questions about nuclear weapons and to what extent are they covered, and drones, which are kind of an emerging issue of the capability to kill by drone from places like Florida, where you can still be driving a drone in Afghanistan.
Yeah, absolutely. I definitely saw drones being used in Afghanistan where the pilots were sitting in Las Vegas. So the thing is, international law requires that humans make a distinction between combatants and non-combatants. And the UAVs that are used right now, or the media calls drones, these are flown by pilots who are making distinctions and making decisions. Sometimes they're special forces or other military forces.
We've lost you briefly, Bruce. I'm just going to wait for Bruce to come back here. Those of you that are online know that he cut out briefly earlier in the presentation and came right back. So,
can you hear me okay now?
Yep, we got you now.
Okay, so there's this principle of distinction, meaning that the military person
and we've lost you again. Not sure. So while we're waiting for Bruce's connection to come back, just so everyone knows, we will wrap this up at 1 o'clock or shortly thereafter. And many of you are still online and are interested in the answers that Bruce is providing. Please use the chat function as your preferred way to put a question forward. And Bruce, have we got you back?
Yeah, I think the internet got unstable there for a minute, I guess.
You're back.
So The question about drones is they're not autonomous. They don't act automatically. They're not robots. They're handled by humans, and humans are making choices about when to.
You're going unstable again, Bruce. It's funny that this is happening at the end of your presentation. It's unfortunate. Just wait till we get you back.
Concerns about, I don't know if you can hear me yet.
You're back now. You're back now.
Well, Canada had concerns with landmines, for example, because there is no person making a decision about landmines. You step on them and they explode, and it doesn't know if it's a 4-year-old child or a combatant. So the future is what is going to happen with autonomous drones, where they act as robots or there's an AI that's controlling them. And I think international law is not going to be supportive of seeing those kinds of weapons. Because there is no human being making a choice, and that's really the main concern. When it comes to nuclear weapons, there are lots of efforts being made to reduce nuclear weapons and proliferation of nuclear weapons. Because they are weapons of mass destruction, they're indiscriminate. They're very difficult to just use against a single military target, which is why you don't see them used. And there's always the risk of another country using them back against you. So if you use them first, you might be facing a nuclear weapon attack yourself. But it's because they have too much damage associated with them that they're not used.
That would make sense. There's a question that's been posted regarding Chapter 7, UN. Can this sometimes play into the hands of a dictator? And I think this speaks to something you touched on earlier, which is, the obligation or respect for the sovereignty of nations versus the emerging duty to protect or responsibility to protect. And in that latter case, I think that was largely championed by Lloyd Axworthy from Canada, if I'm not mistaken.
Yeah, him and Bill Clinton both were proponents of the responsibility to protect. The thing is, the willingness of the international community to intervene really depends on the size of the country they're going to intervene against and their military capability, which is why North Korea is allowed to sit as they do, because the cost of engaging with North Korea in a military conflict is just too high. It's just too high. And so the status quo just sort of bumbles along because the alternative is just too ugly.
And yet at the same time, as you mentioned earlier, we're living in an asymmetrical world where small powers like North Korea can develop nuclear weapons and be, larger players than their status in the world or their population would create. And this creates new problems in this area. I don't know if you have a chance to comment on that.
Yeah, and cyber warfare also creates the ability for very small countries or even small groups with high capability of having very big strategic effects. That's certainly a risk that smaller countries could develop and use against larger countries. Certainly.
Do you see any hopes for UN reform at all that might improve the status quo? I mean, the UN has been around, as you said, since the end of World War II. It's not perfect. I mean, the International War Crimes Court is not perfect either. UN reform is something we often talk about, but I personally have not seen any momentum.
Yeah, so if you want to change the UN, you have to bring along the 200 member countries of the UN to some agreement, virtually unanimous agreement, really, to get that change. And because of the scope of agreement that's required, there's really no stomach for the battle and the years it would take to make that happen. So I don't think we'll see UN reform anytime soon. What you might see though, are other organizations that are a little more nimble, a little more responsive, starting to come forward and being more persuasive or use more. So you don't see the UN really trying to contain the Ukraine or some of the moves being made by Russia. You see NATO doing that because it's a smaller group of countries that are similar minded and have resources. And the UN is less of a player, and you might start to see regional arrangements like that become more prominent.
I think you've touched on an important aspect of, working together, at least the nations that have the most influence over the emerging law of war. As one of the chat comments mentions, the carpet bombing, you mentioned carpet bombing as well during World War II, in many respects would be considered a war crime today. More accurate weaponry, of course, suggests that we might not rely on carpet bombing in the future, but it is, the point being is it's very much an emerging field. I had a question attached to that, of course. I'm curious as to what I think it speaks to the importance of not functioning unilaterally. Certainly some of the larger powers in the world tend to function in recent years, especially unilaterally or simply bilaterally, as opposed to sort of a combined effort. And I'm assuming you would agree that unless the important parties in the world at the United Nations work together on this, it's not going to evolve further, at least in the short term.
Yeah, that's what you're sort of putting your finger on, is kind of the different worldviews that particularly American presidents have had that are very different. Barack Obama was very much a multilateralist and would try to put together coalitions and partners and come with a consensus of many nations. Donald Trump is more America first. America goes it alone. But you have to, he's had a trade war with China for a few years, America against China in this trade war. If he had had European partners in Canada and Australia, and that whole coalition had come together in a trade war with China, it would have been a lot more persuasive to have more numbers and more consensus that way.
Great. And I think that's going to bring us pretty much to the end of our presentation today, Bruce. It's been a privilege getting to know you on the screen. And of course, we have a mutual acquaintance that introduced us, and I wanted to thank Ed Gallagher for that. Again, my thanks for your presentation today. It was comprehensive. I see some really positive comments on the chat column. We look forward to sharing your presentation with others, and I'm sure others will take the opportunity to view it that missed out today. Your depiction of Canada as a smaller nation, but still a member of the G7, a desired partner in international efforts to limit the negative impacts of combat and to move the world, progressively forward, I think are important and deserve the support of us as Canadians. So I wanted to thank you for that, and thank you again for your service personally. And on that note, we'll say goodbye and look forward to our next chance to meet.
All right, thank you. Goodbye, everybody.
Thanks everybody for attending. I invite you to visit the adralberta.com website or the FOAJ website to sign up for newsletters, future webinars, and just learning opportunities, whether it's in administrative justice or ADR. There is obviously, as you might have gathered, an obvious connection between ADR and international efforts, both with militaries and non-military players. So some have taken their learnings in alternative dispute resolution, administrative justice, and they've moved that into the international forum. And some of those people are online today. Again, thanks for being with us today. We look forward to our next opportunity to meet. Thanks again, Bruce.